We conclude meeting 19 with further considerations about judicial impartiality. In particular, we focus on the possibility that a judge may seem to be, or in fact be, partial to personal financial interests implicated in a matter, whether directly or indirectly. Model Rule of Judicial Conduct 2.11, Disqualification, reads, the judge's impartiality might reasonably be questioned if the judge knows that he or she, individually or as a fiduciary, or the judge's spouse, domestic partner, parent, or child, or any other member of the judge's family residing in the judge's household, has an economic interest in the subject matter in controversy or in a party to the proceeding. The disqualification rule acknowledges that judges have economic interests at stake. The term economic interest is defined, and we will return to what it means in a moment. But a reasonable question about a judge's impartiality only where the judge knows she has an economic interest. Many, if not most, judges are well off financially, often having had lucrative private practices, which they cannot continue while on the bench. Not a few judges have extensive, diversified portfolios of stocks and bonds, which they might prefer not to manage themselves. Thus, a judge might not even know whether she has an economic interest in the matter, much less whether her co-resident spouse, adult child, or parent has. In light of this, the disqualification rule provides that a judge shall keep informed about the judge's personal and fiduciary and economic interests, and make a reasonable effort to keep informed about the personal economic interests of the judge's spouse or domestic partner and minor children residing in the judge's household. Note that a judge is not directed to keep up with the finances of adult children and parents living with her. And again, the rule addresses only those relatives living under the same roof as the judge. Shall keep informed. Now, what exactly is meant by the term economic interest? Comment 6 tells us that an economic interest, as set forth in the terminology section, means ownership of more than a de minimis legal or equitable interest. It does not include an interest in the individual holdings within a mutual or common investment fund. So there is a de minimis exclusion as well as a mutual fund exclusion. But where is the line between the de minimis and the not de minimis? Is it based on the fraction of the judge's total assets a certain holding represents? Is it to be measured by a cost basis? Or is it to be marked to market? Is it a function of how much is at stake in the matter? For example, if a judge bought 100 shares of Apple for $10 a share decades ago, is her economic interest in the outcome of a slip and fall personal injury suit against an Apple store the same as it would be if the suit alleged patent infringement? A more basic issue is this: how is a party or counsel for a party to know what the judge and his household own? The rules of civil discovery surely do not entitle parties to a proceeding routinely to request this, and it need not be publicly disclosed. The rules of judicial conduct contemplate that the judge is to police herself. Comment 2 to the disqualification rule provides, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. In general, and not only with regard to economic interests, the judge is obligated to disqualify herself if required by the rules, even if no party has so moved. Comment 5 states, a judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. So, a judge is supposed to put on the record any economic interest that might reasonably be thought more than de minimis, even if the judge thinks it's not. Counsel might consider advising their clients to consent to the judge's continuing to preside rather than to move the judge's recusal. By disclosing her economic interest rather than recusing herself on her own, the judge will have already made it clear what she thinks, and she might deny the motion. We now turn to a special kind of economic interest that could affect judicial impartiality. It has to do with judicial elections. Federal judges serve during good behavior, and their salaries cannot be reduced. The framers of the Constitution included these provisions in Article 3 in order to assure that federal judges are independent of political pressures. Federal judges are, to that extent, unaccountable. In most other constitutional democracies, judges are similarly insulated from political pressures, although without the grant of lifetime tenure. Oddly, the tradition in the several states of the United States is out of step. Judges are chosen by popular election. This practice is out of step with how the judicial role is normally understood, it seems. Judges don't make the rules, they only call balls and strikes. Baseball umpires are not chosen by popular election, and it's a good thing, too, isn't it? Model Rule 4.1 provides, a judge plays a role different from that of a legislator or executive branch official. Rather than making decisions based upon the expressed views or preferences of the electorate, a judge makes decisions based upon the law and the facts of every case. Separation of powers doctrine tells us that judges should not be swayed by the winds of politics. The model rules reflect this sentiment insofar as they forbid judicial candidates from running as partisans. But the model rules accept the custom in the states that fill judicial offices by popular vote. Therefore, judges and judicial candidates must, to the greatest extent possible, be free and appear to be free from political influence and political pressure. The greatest extent possible is unobtainable as long as the judge and would-be judge have to win over voters. The model rules forbid judicial candidates from soliciting money for their campaigns and, to some extent, from partisan campaigning. Even so, judicial campaigns can get as ugly as any other kind, and judges are not forbidden to campaign, and campaigns are not cheap. A judge may not solicit contributions, but contributions can be made, subject to a frayed network of regulations that we do not have time to cover. What about this money? The disqualification rule states, the judge's impartiality might reasonably be questioned if the judge knows or learns by means of a timely motion that a party, a party's lawyer, or the law firm of a party's lawyer has, within the previous insert number of years, made aggregate contribution to the judge's campaign in an amount that is greater than insert amount for an individual or insert amount for an entity, or is reasonable and appropriate for an individual or an entity. The two alternative formulas are presented to the states that elect judges. The first alternative is to set a fixed cap. The second alternative goes with a vague, reasonable and appropriate standard. Only 5 states have set a fixed cap, following the first alternative. The second alternative is vague, of course. The decision of the United States Supreme Court has established that the Due Process Clause of the 5th and 14th Amendments serves as a separate outer limit. In the 2009 case of Caperton versus A.T. Massey Coal Company, the court held that where campaign contributions from Don Blankenship, CEO of Massey Coal, quote, had a significant and disproportionate influence, unquote, of the election of Brent Benjamin to the state Supreme Court, the risk of Benjamin's actual bias in favor of Massey was sufficiently substantial to require that justice's disqualification under the Due Process Clause. After a jury found Massey liable to Caperton for $50 million in damages, West Virginia held judicial elections. Knowing the state Supreme Court of Appeals would consider the appeal, Blankenship supported Brent Benjamin rather than the incumbent justice seeking re-election. In addition to contributing the $1,000 statutory maximum to Benjamin's campaign committee, Blankenship donated almost $2.5 million to, and for the sake of the kids, a political organization formed under 26 U.S.C. Section 527. This organization opposed the incumbent and supported Benjamin. This was not all. Blankenship spent, in addition, just over $500,000 on independent expenditures for direct mailings and letters soliciting donations, as well as television and newspaper advertisements. Blankenship's $3 million in contributions exceeded the total amount spent by all other Benjamin supporters and by Benjamin's own committee. Motions to recuse now Justice Benjamin were denied, and the court, by a vote of 3-2, reversed Caperton's $50 million judgment. Noting that most matters relating to judicial disqualification do not rise to a constitutional level, Justice Kennedy, for this court, held that the case presented circumstances, quote, in which experience teaches that the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. He went on, we conclude that there is a serious risk of actual bias based on objective and reasonable perceptions when a person with a personal stake in a particular case had a significant and disproportionate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case was pending or imminent. The inquiry centers on the contribution's relative size in comparison to the total amount of money contributed to the campaign, the total amount spent in the election, and the apparent effect such contribution had on the outcome of the election. The relevant rule adopted by the Georgia Supreme Court requires recusal when the judge has received or benefited from an aggregate amount of campaign contributions or support so as to create a reasonable question as to the judge's impartiality. The Georgia rule goes on to identify a number of factors that may be relevant, such as amount, timing, impact, prior relationship, and the nature of the pending case. The commentary to the Georgia rule states, however, if contributions made to a judicial candidate or to that candidate's campaign are permitted by the law and do not exceed the maximum allowable contribution, then there is no mandatory requirement that the judge recuse. Do not exceed the maximum allowable contribution. The comment continues, there is a rebuttable presumption that there is no per se basis for disqualification where the aggregate contributions are equal to or less than the maximum allowable contribution permitted by law. If the contributions in question are themselves within legal limits, a recusal motion will fail unless it is supported with an affidavit setting out specific factors that rebut the safe harbor presumption.